Hi, I'm Cathy Pilkington, and I've got today with me Judge Borah from the Illinois Human Rights Commission. And Judge Borah today is going to give some practice pointers for attorneys who are litigating cases in front of the Human Rights Commission. So Judge Borah, why don't you give us your first practice pointer?
As soon as a client comes through your door, sits in front of you, evaluate the case, evaluate the facts that are interpreted by your client. As I used to tell the client, it's not what the truth is, it's what we could prove. And that's exactly what you have to do. You can't take a case based on emotion, because in many respects, in employment law or discrimination law in all the areas of the Illinois Human Rights Act, there are less tangible evidentiary facts out there for you to investigate. You will have individuals who are the foreman or supervisor or even your own client want to spin the facts on your dime and your time. So make sure you have a theory. Whatever the theory is, make sure you know the prima facie case. Make sure you could prove it, and then file the charge with the Illinois Department of Human Rights. Now, don't forget about it, follow it, because facts are going to change in the employment case or in the discrimination case. And those facts may lead you to amend the charge and eventually amend the complaint, or to make sure that the complaint filed with the commission is full and complete, and you did not just blow a statute of limitations, which is 180 days. So if you file a charge, forget about it until the department renders a determination. The 180 days may have passed for a second count or a retaliation charge or a wrongful or constructive discharge count in your complaint. So be very, very careful.
Okay. Tell us the second practice pointer concerning damages.
Learn your damages. I have seen numerous cases that are your garden variety type of case, and this is, we call it as well as federal court, garden variety discrimination cases, in which maybe the damages are such in which it is not a huge amount. You still have the idea of making your client whole if you're representing the complainant or the plaintiff, which means receiving the job back, back wages, any type of fees or expenses as it relates to the litigation, or expenses in living until such time that the litigation has been completed. Also, there are other damages, but you have to calculate it. Emotional duress, very important as it relates to the nature and duration of the emotional duress. But you have to prove those damages, and that is just as important as proving your liability. I have seen over and over again lawyers that will prove the liability aspect of the case and forget to prove damages, and especially emotional duress. If it's garden variety, then the plaintiff can get on the stand and talk about his or her feelings and what has been suffered. But if you're going to get into the larger money as it relates to compensation for emotional duress, then medicals will have to be necessary.
Is there a practice pointer concerning medical records?
Well, know your client again. It's one of those points that if you're going to claim that emotional duress is very, very deep, and therefore compensation is necessary in a more than garden variety, then the respondent or the defendant will also want to investigate and depose or look at those medical records to see if there are other areas beside the discharge, beside the discrimination, that may have caused or contributed to emotional duress. It could be a divorce, it could be drug addiction, it could be any other aspect that would cause emotional duress, which would be a mitigation of the emotional duress damages. Also remember, punitive damages are not available in the state of Illinois, either in circuit court or the commission.
Give me another practice pointer concerning discovery.
Discovery, please don't play the game of, I think the Supreme Court calls it the war of inconvenience. The fact of the matter is, hide the pea, catch me if you can, or a fishing expedition, which primarily means that the attorney really doesn't know the theory of the case and just wants the shotgun computer-generated discovery with boilerplate responses. It's save the time and the money, be specific with your discovery, and as it relates to the defendant, sometimes it's just better off to go ahead and give what you have because it shows that a non-discriminatory reason took place, and it would save a heck of a lot of money and time.
And what practice pointers can you give us concerning the trial?
First of all, if you put on a witness, why is this person testifying? There are many times in which a person is testifying and there is no reason as it relates to the prima facie case, mitigation of damages, the affirmative defenses. There's no reason except to hit some sort of emotional chord. Pick your witnesses, organize your exhibits, make sure you lay foundations. The opening and closing are very important. Remember, it's a bench trial, and I am very interested with regard to the opening statement and closing arguments. Be very prepared. It's not informal. It is comparable to the circuit court or federal court when you appear before the commission as it relates to a trial.
Those are their practice pointers from Judge William Borah of the Illinois Human Rights Commission.
Thank you, Beth.